Hello, YouTube. Another special live edition bringing you good news today. We have an update in a big case that could possibly go to the U.S. Supreme Court. This one's called Duncan v. Bonta, which actually started back in 2017, and we're talking about the California mag ban. So California's ban and mandatory dispossession of firearm magazines holding more than 10 rounds was actually amended by something called Proposition 63 and was preliminarily enjoined back in 2017. That's all a very fancy way of saying that this particular court, the same court we're now talking about, some 6 to 7 years later, actually enjoined and stopped the enforcement of that law back in 2017. Now, that decision wound up getting appealed, and it was affirmed on appeal. In other words, it went from the district court, the federal district court, which is the same court we're talking about right now, and you're going to see how this all connects. Okay. And by the way, even if you don't care about California, don't think for a second this is not going to be relevant to you. This is relevant to all of us. All of us. Okay. So that decision wound up getting kicked up to the Ninth Circuit Court of Appeals. The Ninth Circuit said, yep, good to go, was appealed, or pardon, was upheld, and then it wound up being reheard en banc. Okay. Being reheard en banc basically is a very fancy way of saying that everybody got together in the Ninth Circuit and wound up rehearing it all, not just the 3-judge panels originally assigned to, but everybody. It was reheard and then reversed en banc. Okay, so the Second Amendment then lost on the redo in the Ninth Circuit. And then in 2022, the U.S. Supreme Court granted certiorari. That's a very fancy way of saying they said, all right, we'll hear this case. And then they vacated the appellate en banc decision and remanded the case. Why? Well, you may have heard about this thing called the Bruen decision. And so they basically sent it back down and said, look, Court of Appeals, you guys need to redecide this case, now taking the new law from the Bruen decision, which I'll be getting to in a moment. So the Court of Appeals, in turn, said, yeah, this is kind of too hot to handle. We're going to send this back down to the district court. And that's where we are right now, all thanks to the Bruen decision. You know, they always say, of course, all roads lead to Rome. All roads lead to the Bruen decision. So what is this Bruen decision? Well, super quickly here, because this is all going to stack and build on. I want to make sure that all of you can follow this, okay? So the Bruen decision gave us the new test of how we are to analytically and constitutionally assess Second Amendment laws and regulations for whether or not they're going to be constitutional. So before that, there's basically different levels of tests. You had strict scrutiny, intermediate scrutiny, rational basis. You'd get into interest balancing, all this legal mumbo jumbo for basically, are we or are we Well, this is an so is that good enough or not? Very technical. Hopefully you're following that. And the U.S. Supreme Court said, you know what? We're kind of done with this game. Now we've got something new for the Second Amendment. So to determine whether or not law is going to be protected and how this all works out, there's going to be a test, the Bruen test, Bruen, if you want to Google that. First, the court must ask whether the Second Amendment applies by its terms. So when the Second Amendment's plain text covers an individual's conduct, what they're talking about, what the law is theoretically prohibiting or seeking to regulate, then the Constitution presumptively protects that conduct. Second, we ask whether the given gun restriction or law or regulation is consistent with the nation's historical tradition of firearm regulation. So the government bears the burden of proof of demonstrating that there is a tradition that supports the challenged law. And only by showing that the law does not tread on the historical scope of the right to the government's justice to justify its regulation. So again, the government bears the burden of proof of showing, yep, this is the regulation we're doing right now. And historically, we have something that's very similar to that. Okay. The second step is that the Fifth Circuit, and the Fifth Circuit's been a big thing. We've been talking about Mock v. Garland, just on and on and on. Been a big circuit putting out pro-Second Amendment decisions. So the second step, and the Fifth Circuit kind of gets into this, alludes to this in one of their decisions, requires both close attention to history as well as analogical reasoning. So Bruen did not basically say, look, there's no such thing as legislative innovation. We're all done. Okay, so Bruen's not saying if there's no historical twin, everything's illegal. I know maybe a lot of us would prefer that to be the case, but they left the door open and people don't really talk about that much. To the contrary, quote, the Constitution can and must apply to circumstances beyond those the founders specifically anticipated, end quote. So, what does that mean that we're looking for when we're talking about this tradition? Well, it's well accepted limits on the right to bear arms manifested by a tangible practice of comparable gun regulations. Okay, that's a lot to drink in there. But how do we know whether an older regulatory practice is comparable? So if we're trying to compare some sort of practice from the 19th century, 18th century, 17th century, going back to colonial time and so forth, how do we know if it's comparable? Well, again, the US Supreme Court in the Bruen decision spoke to this. Bruen helpfully gave us two kind of conceptual roadmaps or two conceptual pathways on how to get there. If the modern regulation addresses a general societal problem that has persisted since the 18th century, then basically the lack of a distinctly similar historical regulation addressing that same problem is directly relevant to the challenged regulation as being inconsistent with the Second Amendment. In other words, if we're talking about something like carrying a firearm, just, hypothetically, well, folks could be carrying firearms back in the 17th and 18th centuries. So the fact that you had this as a potential societal issue that was out there with a corresponding general lack of regulation goes to show us that, they had this problem and we have a lack of regulation. Therefore, things that now try to regulate it, probably not going to work out. Okay. But if a modern law addresses, quote, unprecedented societal concerns or dramatic technological changes, end quote, then it calls for what the courts have described as a more nuanced approach. We must reason by analogy to determine whether older regulations are relevantly similar to modern law. So Bruen acknowledged the difficulty of determining whether two laws are, quote, relevantly similar, end quote. Bruen clarified that two laws are indeed relevantly similar if they share a common why as well as a how. They must both address a comparable problem. So the why and the place and a comparable burden on the rights holder, that's the how. The bottom line is that Bruen instructs us that we are looking for a representative historical analog, not a historical twin. Okay, so that's some of the background here that I just wanted to make sure I hit you with. Let's go back to Duncan v. Bonta now, and you're going to see how, now that we've kind of set up some of these dominoes, how they start to fall. And by the way, it's a 71-page decision linked in the description box below. If you think I'm going to be able to cover that all right now, I don't know what to tell you. It's not happening. So if you want specific aspects of this case broken down in greater detail, I'm more than happy to do that. Let me know after this video is done going live and we wrapped it. There will, of course, be a comment field. Right now, there's live chat, but there will be a comment field. Let me know in that comment field if there's particular areas. But for now, we press on. So this case is about a California state law that makes it a crime to keep and bear common firearm magazines, typically possessed for lawful purposes. And a lot of what I'm saying, by the way, is coming directly from the case. Based on the text, history, and tradition of the Second Amendment, this law is clearly unconstitutional. That's a direct quote from the judge in this case, not a direct Tom Grieve quote. I wish that was my quote, but that's not my quote. That's the quote from the judge in this case. The detachable firearms magazine solved a problem with historic firearms, namely running out of ammunition and having to slowly reload a firearm. As a result, in the realm and world of firearms, magazines that hold more than 10 rounds are possibly the most commonly owned thing in America. Newsflash in case you didn't know that. These larger magazines number over 100 million in circulation. 100 million. Yet, regardless of the overwhelmingly popular and the popularity of larger magazines, California continues to prohibit any magazines capable of holding more than 10 rounds. There is no American tradition of limiting ammunition capacity, and the 10-round limit has no historical pedigree, and it's arbitrary and capricious as a result. Furthermore, again, another quote from a quote, from the court, it is extreme. Our federal government and most states impose no limits. And in the states where there are limits that are imposed, there is definitely no consensus about what that limit ought to be. So as an example, Delaware landed on 17-round magazine limit. Illinois limits it at 15 for handguns and 10 for rifles. Vermont, 15 rounds for handguns, 10 guns for rifles. Colorado opted for 15-round limit for handguns and rifles, and they also put a restriction of a 20-inch tube limit on shotguns. New York did try a 7-round limit. However, that did not work out. They got struck down in a case called New York State and Rifle Pistol Association v. Cuomo. That I think was from the Second Circuit Court of Appeals back in 2015, I want to say. Fact check me on that, internet. New Jersey also, by the way, started with a 15-round magazine and then decided, hey, there's got to be this 15-round magazine loophole out there. Let's back that down to 10 rounds. So let's be clear. The fact that there exists so many different cutoffs underscores and ennobles the fact that these are arbitrary numbers chosen by bureaucrats with no science or evidence behind them, period, full stop. So how is California trying to sneak this past the goal line? Well, we just talked about the test that the United States Supreme Court set up in the Bruen decision, which came out in June of 2022. Those are the goalposts. The court created this test to get out, as I mentioned before, of this warped legal minefield with interest balancing tests, rational basis, intermediate scrutiny, all this other kind of stuff, right? Yep. Surprise, surprise. All too often, the Second Amendment loses when the chips are down, when we start using these, frankly, made up tests, okay? So what is California trying to argue in court now? And by the way, if California is doing this, just like I said before, all this stuff travels. So if California is trying to do it now, it's New York tomorrow, Illinois the day after that, Maryland after that, Colorado, New Mexico, Vermont. The list just keeps going because this just travels. It all absolutely travels. So just because you may not live in one of these states right now, and even if you live in a state where you're like, there's no way, if you live in Wyoming, there's just no way you have to worry about this kind of stuff, God willing. Well, you will if it migrates to DC. See what I mean by traveling? So you have to pay attention to what they're arguing today, because it may be in California today, but it's going to be in DC tomorrow. So what is California arguing today? Well, it's what the judge characterized as basically a stealth runaround, the interest balancing test that was explicitly rejected by both Bruen in 2022, as well as one of Bruen's predecessor cases, DC versus Heller back in 2008. What the heck am I talking about? Because California is trying to justify this not by looking at historical tradition, not by looking at even arguing strict scrutiny or something like that. They are instead trying to deem the smaller magazines or, quote, well suited, end quote, for its citizens. Suitability, in turn, is based on a concocted statistics game about what a hypothetical average person needs to defend against an attacker or attackers in a quote unquote average self-defense situation. Based on this hypothetical statistically average case scenario, we'll just call it the Walmart run, okay? The state permits its citizen to have the gun, but the state decides the number of rounds in the gun that it finds suitable for the Walmart run. So here's some examples just to kind of give you a flavor from the case about what California is trying to specifically advocate for. What pieces of evidence are they trying to cite for? What kind of arguments? And just 3 short ones here. Number 1, the Attorney General has demonstrated that LCMs, as they call them, large capacity magazines, are not necessary or even suitable to engage in private self-defense, is one of their claims. So you don't need a normal capacity magazine because they're not even suitable to engage in private self-defense. They go on, quote, nor are large capacity magazines particularly suitable for self-defense, repeating themselves once more. And number 3, the accessory at issue here, namely a large capacity magazine, i.e. a normal capacity magazine, is not well suited for, and here's the word, lawful self-defense, end quote. So let's follow this reasoning. California is claiming, if you get into the weeds, long, deep, dark weeds, but if you get into the weeds of what they're claiming, they're saying that an average self-defense shoot, and I'd be happy to go down in the rabbit hole if you guys want to know the math that they use to get here. The average self-defense shoot, according to California, is 2.2 rounds. By that logic, be grateful they are willing to spot you 10 rounds. But of course, don't forget, just like New Jersey started their line at 15 before saying, why are we giving them 15? We have a 15-round loophole here. Let's drop it to 10 before we get to New York 7 and away we go. Under their logic and analysis, they can limit you to 3 rounds, maybe even 2 if we really want to get strict here. That's where this goes to. And as the judge pointed out, this is all incrementalism on the way to citizen and victim disarmament. Make no mistake about it. In so doing, the state denies a citizen the federal constitutional right to use common weapons of their own choosing for self-defense. There have been, and by the way, there will be times when there are more than 10 rounds that are needed to stop attackers. All right. You have to remember from the Bruen decision, we're talking about common weapons. Common weapons are the ones that are going to be allowed. Bearable weapons, if you want to be specific, common bearable weapons are the ones that are going to be constitutionally protected under the law. There's issues when you get into what's called dangerous and unusual, is basically a blessed concept by the U.S. Supreme Court. I'm not necessarily defending that. I'm just reporting that fact. And again, if you want, I've yet to do, I think, a video on what constitutes the history of dangerous and unusual, though I've touched on it a number of times. I'm not going to touch on it right now. The numbers vary, but some estimates put it at, I think, about 81 million Americans own between 415 million firearms to closing at, I think, 460 million firearms, depending on which study you want to read. Further, millions of Americans across the country own these so-called large capacity magazines. One estimate puts it as basically civilians possessing around 115 million large capacity magazines out of a total of 230 million magazines in circulation. Put another way, half of all magazines in America would be banned in California because they hold more than 10 rounds. A more recent large-scale survey estimates that Americans today own about 542 million rifle and handgun magazines. So basically more than doubling the numbers. You have to double it in order to get to how many are out there. Today own 542 million rifle and handgun magazines that hold more than 10 rounds. 542 million. Obviously, there's a lot of numbers that are all over the place on this, but the bottom math is all the same. The bottom math is that these are extraordinarily common weapons. These are extraordinarily common accessories. But California bans these typically possessed magazines kept and used for self-defense. And of course, why are larger magazines chosen for self-defense? Well, as you've heard me bang about time and time again, crime happens. It happens a lot. One recent estimate actually specifically pinned down the number of times that defensive firearms are used in America every year, at approximately 1.67 million in America every single year. 1.67 million. Another report, and this is something you've heard me cite many, many times as well, which actually came thanks to a President Obama commission study that the Center for Disease Control, the CDC, looked at, came up with a range of numbers between 500,000 defensive firearm uses per year and 3 million. Lawyer math off the top of my head, that's about, I think it's over 8,000 rounds or 8,000 defensive uses of force involving a firearm every single day across America on the high end, and over 1,000 on the low end, over 1,200 on the low end. I've done that math before. Don't be too impressed. I'm trying to remember it. I'm not like dividing, just to be clear. So the judge goes on to rule that magazines are a protected weapon. They are a protected arm, and they're not some kind of extra constitutional accoutrement that falls entirely outside the purview of the Second Amendment and therefore constitutional protections. This is very important because this is something that has been extensively argued and claimed and will be continued to do so. This is going to have to be settled by the U.S. Supreme Court, whether or not accessories, whether it's a pistol grip, whether it is someday, I'm sure we're going to be talking about scopes and red dots and night sights and so forth and weapon mounted lights. But today we're talking about magazines. We're talking about pistol braces. We're talking about stocks that you put butt stocks, i.e. pistol braces and all that kind of stuff. Are those protected under the Second Amendment or are they not protected by the Second Amendment? So in much of the judge's 71-page decision, the judge basically goes through and knocks down those dominoes of saying no, 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 in California, no. That's basically what's going on here in this. So what does this all mean? And kind of what's the tie up? What's the wrap up bottom line to this? Well, first off, if you've not already done so, please take a moment, hit that like button. I actually do enjoy doing these live feeds, and I hope you enjoy getting something out of it as well. I did have to rope Derek into coming back from the office. He's giving me a thumbs up behind the camera. So please let Derek know. Thank you for coming back to make this possible, because I don't know how to operate all this stuff behind the camera here. Here's the bottom line. This is a federal district court decision that enjoins both California and the feds from enforcing the California law. Great. But the judge stayed it for 10 days. This gives California time to appeal it to the Ninth Circuit, which they will do. And of course, off to the races, and it's back to 2017 and 2018 when this case was originally filed. So we'll see where this tracks, and we'll see how this compares to another case that this channel's been closely following, which of course deals with the Protect Illinois Communities Act, or PICA, coming out of Illinois, which is presently parked in the reasonably anti-Second Amendment, anti-gun Seventh Circuit Court of Appeals. Folks, there's a really good chance it's going to be one of these two cases that's going to decide my right and your right about whether or not we can go to prison for possessing a little box that holds more than 10 rounds in it. I'm not asking you to like that. I'm just making a prediction. God willing, all goes the right way. But again, the logic and reasoning that we're seeing here is these are the headwaters that will continue to migrate. All right. Quote of the day. I always love wrapping up with the quote of the day. And it seems like based on the comments, you guys love it when I wrap up on the quote of the day as well. So thank you very much. And always, always, always leave comments, because I do my very best to read them. If you see replies, that's me. All right. Our quote of the day comes from Fyodor Dostoevsky, noted Russian author. It takes something more than intelligence to act intelligently. And sometimes, of course, when we're talking about laws, there's smart people on the other side who are writing these things, but that doesn't mean that they are acting intelligently. So I appreciate you all sticking around. I appreciate you all tuning in. Derek just alt-tabbed. I can see we've got 800 folks or so who've stuck around this long. Love you all. I look forward to reading your comments in the live stream later on. Tom Grieve, Derek signing off. Thanks very much. I'll see you in the next one.